Thank you, Mr. President. Regardless of your views on the matter of abortion, this bill is an example of bad lawmaking. This bill seeks to outlaw individuals or groups who may congregate outside medical clinics in order to stop an abortion from taking place. Mr. President, the allegations made by proponents of reform in this area that this bill is needed to legislate against and enforce against harassment are false. There are already the mechanisms available to do so within New South Wales legislation. It is already an offence under the Crimes Act for an individual or a group to use intimidation or violence to compel a person to refrain from undertaking a lawful activity. Mr. President, furthermore, under the Summary Offences Act, it is an offence to impede the free passage of a person in a public place. Under the Law Enforcement Act 2002, police were provided with move-on powers, powers to deal with public disorder and the ability to manage disruptive protesters. The offences I've just given as examples are already capable of dealing with anyone who presents in the proximity of a sexual health clinic and acts in a way which impedes a person's ability to go about their business. The offences under current acts are already capable of dealing with genuine harassment. This brings us to examine Clause 98D of this bill. Mr. President, for the benefit of those in the gallery or viewing on the webcast, Clause 98D is as follows. Clause 98D makes it an offence for a person who is in a safe access zone to communicate in relation to abortions in a manner that is able to be seen or heard by a person accessing, leaving, attempting to access or leave, or inside a reproductive health clinic at which abortions are provided, and that it is reasonably likely to cause distress or anxiety to any such person. The maximum penalty for the first offence is 50 penalty units or imprisonment for 6 months, or both, and the maximum penalty for any second or subsequent offence is 100 penalty units or imprisonment for 12 months, or both. Mr. President, family members may be unable, once within the proposed 150-metre zone, to engage in a last-minute conversation about what is about to take place. It certainly would rule out the existence of Sarah's Place in Devonshire Street, Surrey Hills, which offers assistance to women going through this tough time in their life. The bill is also unclear whether this could lead to prosecution of people who work for organisations that provide counselling services that just happen to be within a safe access zone. This has caused some distress, as I understand, for Sarah's Place in Surrey Hills. Sarah's Place provides a valuable service to pregnant women who are open to receiving information about all options, all choices available to them. They also have a life-saving impact on women who have been pressured, blackmailed and or subjected to physical violence to force them to complete an abortion. The reason for the concern by Sarah's Place is that they are located in what will become a safe access zone if this bill is enacted.
Could I just ask the Honourable Member for a moment to take this opportunity to welcome into our public gallery, on behalf of all honourable members, to the Legislative Council of this Parliament, student leaders from high schools in New South Wales who are attending the Secondary Schools Leadership Program conducted by the Parliamentary Education Unit. We're currently dealing with the Public Health Amendment Safe Access to Reproductive Health Clinics Bill 2018. Members are giving their second reading speech. You're all most welcome.
Thank you, Mr. President. And I return to my discussion about Sarah's Place and their location. As I'm concerned, as they are, that the impact on the services that they provide could be profound. Could this amendment be used to shut down the vital services that it provides to women? Mr. President, I seek leave to table a letter from Jennifer Gurry, the founder and director of Diamond Women's Support, inquiring what will the impact of this proposed legislation be on Sarah's Place and the services that it offers women. I seek leave. Just tabled off guilt. Thank you, Mr. President. This amendment sets such a low bar for what constitutes an offence in this legislation. Clause 98C prohibits interference with persons accessing or leaving an abortion clinic within the safe access zone. And Anna Walsh, an adjunct associate professor at the School of Law at the University of Notre Dame, Australia, has said that as it provides a non-exhaustive definition of interference that includes harass, intimidate, beset, threaten, hinder, obstruct, or impede by any means, these examples do not constrain the interpretation of this provision and can lead to a wider application by the courts, especially if the assumption underlying the bill that people who participate in prayer vigils, sidewalk counselling, sidewalk vigils and other counselling services cause harm to women, if that is assumed as a fact, then that is a great risk, Mr. President. This is the real problem with what is being proposed in this particular bill. A person can be standing somewhere on the footpath, not obstructing anyone, not intimidating anyone, and simply hand out a flyer outlining alternatives to abortion, and you are in breach of this proposed law, with a threat of 6 months jail for the first offence and 12 months jail for the second and subsequent offences. The threat of jail for handing out a flyer is not an absurd suggestion, because the heading to Part 98D sets such an incredibly low bar as to what is considered to be an offence. All that is required for it to be an offence is causing actual or potential distress or anxiety to persons in the safe access zone. The bar is so low that it is possible that a friend or family member, while accompanying women to abortion clinics, could potentially fall foul of this section merely for asking if they are sure they want to go through with the procedure. Surely, Mr. President, surely this is out of line with community expectations. The right to assembly is a fundamental belief of many in this place and, of course, within our community. The right to assembly can be traced all the way back to the Magna Carta. There was a 2015 briefing paper, Protest and the Law in New South Wales, by the Parliamentary Library, and it stated, the common law right to assembly has been expressly recognised by Australian courts, including the High Court of Australia and the New South Wales Supreme Court. It quoted Daniel McGlone in the Right to Protest, which said that this illustrates an acceptance of the role of protest as part of democratic systems of government. The briefing paper highlights a number of examples of what courts of law in this country have in fact said. Freedom of assembly and speech are important democratic rights, precious democratic rights, and common law freedoms. Peaceful assemblies are perfectly reasonable and entirely acceptable modes of behaviour in a democracy, and peaceful assemblies are integral to a democratic system of government and way of life. Anti-protest laws have recently faced challenge within the legal system, and with one recent example with the case of Bob Brown protesting trees in Tasmania, the challenge was successful, with the High Court striking the Tasmanian legislation down. So too, this bill may be unconstitutional in its current form. Ultimately, Mr. President, if this bill passes, it will be likely to be decided in the High Court at some point in the future if we have met the test to restrict this freedom. The High Court will likely do that later this year with the Victorian and Tasmanian versions of this legislation. I don't wish to make a prediction of those cases, but what I do know is that just because a court says that we may be able to restrict these assemblies, well, Mr. President, it doesn't mean that we should legislate to do so. Oddly, the Honourable Penny Sharp, in her second reading speech, compared her proposed safe access zones to the declared approach distance for whales of 300 metres. She said, and I quote, "I note that in New South Wales, the whales that are currently migrating up our coastline are given a 300-metre exclusion zone by law for their health and well-being. It is ironic that in New South Wales we have not been prepared to give women that same protection." There's a very strange analogy. The exclusion zone around whales is actually as low as 30 metres for swimmers, but the zone of 300 metres, which the honourable member refers to, is for watercraft that could significantly injure animals which make unpredictable movements in the water. In addition, the Biodiversity Conservation Act 2016 doesn't threaten jail time for anyone who should be nearby praying the rosaries in their boat. But most of all, the reason why we give whales such a wide berth during this period...
Interjections.
The reason why we give...
Have an opportunity to speak and they should be heard in silence.
But most of all, the reason why we give whales such a wide berth during this period is because we value young life in its formative stages. What a strange analogy to use when we are here discussing the ending of a young life. In the lead up to today's debate, I have met with and received correspondence from many people who participate in footpath prayer vigils and counselling services. These people told me and my colleagues that they do not seek to intimidate, harass or obstruct women from attending abortion clinics, but rather they offer support for women who feel abortion is their only choice, whether it is due to financial restraints, a lack of support services, or even reproductive coercion, which is a form of domestic abuse that these volunteers hope to be there to be able to assist with. It is a sad reality that some women experience a form of reproductive coercion where a male forces his partner to have an abortion. I received an email from one woman who said that as a young university student, I was pressured by a boyfriend to take an abortion pill, something I will forever regret. There was no one to offer me the moral support I needed to make my own decision or to give me any informed consent. This story is not unique. At a recent panel convened by the organisation We Support Women, we heard from one student who attends an abortion clinic weekly to hand out pamphlets that has the contact numbers of counsellors and doctors willing to provide free pre- and postnatal care. She said that she had witnessed women enter an abortion clinic against their own accord. She continued, "Often there is someone, a partner or a parent, physically pushing them along. Sometimes they're even crying as they enter." Mr. President, this bill could result in that student going to jail simply for handing out a pamphlet offering free medical care. In her second reading speech, the Honourable Penny Sharp claimed that those sidewalk counsellors do not know and they do not care. They do not care about those women, and I quote. I disagree, and I disagree strongly. And I believe that the opposite is in fact true. Those sidewalk counsellors care deeply about women. They are volunteering their own time for honourable reasons. They offer support that these women will not receive once they enter an abortion clinic that operates on a profit motive. One young woman who I met with said to me, even if there was only one woman who, because of us, didn't feel as though she had no choice but to terminate her pregnancy, we will do it all and more. In their opinion, they know of 9 little boys and girls who are here in this world today and receiving support because they were there to offer it. Groups in other jurisdictions claim to have assisted hundreds of lives to be saved, and support provided to families to make it through these tough times and tough decisions and come out the other side. Mr. President, the term pro-choice gets used a lot in these debates. But what could be a better example of choice than to offer support and another choice to these women? So I respectfully disagree with the Honourable Penny Sharp. While the proponents of this bill seek to protect those from the upset that can be caused by those who are not behaving in line with what the community expect outside these clinics, there are also those who do the right thing for the right reasons, and I believe that they do so because they care for that woman and her child long after that day of that visit and long after that memory has gone. And they care for the anguish that can linger for life after that decision has been made and the procedure has been done. This is a poor bill, Mr. President, and it is an attack on our values. It is poorly written. It has questions remaining as to what its impact will be throughout New South Wales and also its constitutionality. The reasons given as justification for this bill are questionable at best, but certainly should not attract a 12-month conviction. But most of all, if allowing for volunteer counsellors to offer support to women If that was even to save one life, is that not enough justification to allow them to offer that support? Mr. President, I cannot support this bill.